Well, let's move on to some other stories now, where the Supreme Court of India will today pronounce its verdict on whether the right to privacy is a fundamental right under the Indian Constitution. The question about the constitutional status of the right to privacy rose way back in 2012. Back then, retired High Court Judge K.S. Puttaswamy, who had led the batch of petitions, had challenged the UPA government's decision to introduce the biometric data-enabled Aadhaar identification for citizens. Now, the petitions were then referred to a 5-judge constitutional bench on the 11th of August 2015, following which the 5-judge bench, led by Chief Justice of India J.S. Keher, met on the 18th of July. But the bench was dissolved owing to its inadequate strength, following which a 9-judge constitutional bench began hearing the case from the 19th of July. It has concluded its hearing on the 2nd of August and had reserved the judgment. While reserving the verdict, the bench had voiced concern over the possible misuse of personal information in the public domain, and it said that the protection of the concept of privacy at the present technological era was a losing battle. During the arguments, the bench had observed that the right to privacy cannot be an absolute right, and the state can endorse its power to put reasonable restrictions on the right to privacy of an individual. But what exactly is the discourse of right to privacy? Here's a report.
Privacy is simply a human right which allows an individual to express autonomy and right to bodily integrity. The question on everyone's mind is whether a right to privacy is a fundamental right, and does it allow an individual to be left alone? The notion of privacy is embedded in the right to dignity, which is further protected by the right to equality guaranteed by Article 14 of the Indian Constitution. This aspect of privacy extends to all human beings in equal measure, a concept which is not limited to just the elite in India. But the amorphous concept of privacy is questionable and can lead to a situation of administrative paralysis. A 9-judge constitutional bench of the Apex Court, while hearing the arguments in the case, has now questioned to what extent anonymity can be allowed and what are the contours of this right. Privacy is protected under right to equality and dignity. Privacy is right to liberty and freedom in action. Dignity extends to all human beings in equal measure. Absolute privacy can cause administrative paralysis. Right to privacy further opens a discourse on data protection and information dissemination. In the age of WhatsApp and Facebook, India does not have a data protection law. Even then, if an individual discloses any personal information, it is in the realm of a constitutional liberty. But the Supreme Court observed whether demanding right to privacy was a losing battle in a technological era. The high-voltage hearing on right to privacy invited heated arguments where the Indian government opposed the inclusion of a right to privacy as a fundamental right. It remains to be seen whether the right to privacy will be declared inalienable and inherent to most of the fundamental right, which is the right to liberty. Bureau Report, WION.